All right, I'm going to go ahead and get us started because we have a lot that we'd like to cover in just an hour of your time. So welcome everyone. Thank you so much for being here. My name is Charlotte Saul and I'm NIJC's Pro Bono Manager. Before we get started, I just want to make one or two quick logistical notes. So first, if you have questions throughout this presentation, please submit them through the Q&A feature that you should see at the bottom of your screen. This allows us to effectively see questions as they're coming in, and we will try to answer as many of them as we can. This webinar will also be recorded, so if there's anyone who you know who isn't able to attend live, we will be distributing the link afterwards so folks can watch it after. And with that, I want to thank you all again for being here, and I will now hand it off to our Executive Director, Mary Meg McCarthy, for some introductory remarks.
Thank you for joining us this afternoon. This is a critical time in our country's history. It's a critical time for immigrant rights. Less than 2 weeks into 2026, 4 people already have died in ICE detention centers, and we have witnessed horrific violence by ICE in our communities, including Renee Nicole Good's murder in Minneapolis. This pace of escalating actions by the Trump administration and the accompanying tragedies and fear we are all being faced to endure make it challenging, but even more urgent for all of us to continue to work together to protect immigrant rights and the rule of law. NIJC is not deterred, and judging by nearly 800 people on this call, neither are you. NIJC is winning cases, but where we lose, we are also building strong records for appeal and documenting the erroneous decisions and illegal interpretations of the law. NIJC is litigating cases in collaboration with our partners, including the Illinois Coalition for Immigrant and Refugee Rights, Organized Communities Against Deportations, the ACLU, Democracy Forward, our pro bono partners, and many more. Together with our partners, we are defending due process, fighting against the expansion of unlawful arrests, arbitrary detention, the disappearances of community members, and holding this administration accountable in the courts. Today, you will hear from NIJC legal experts, Azadeh Irfani, Director of Policy, Jen Barbe, Associate Director of Detention, Lisa Koop, NIJC's National Legal Director, and Karen Zwick, Director of Litigation. They will provide you with information as NIJC implements its strategy, its multi-strategy, to defend the rights of immigrant neighbors and the rule of law. Before I pass this to Azadeh, let me conclude by encouraging each one of you to stay involved. We have to do this together. If not, we will not prevail. Join our email alerts and check our websites for volunteer opportunities. With that, I pass it on to Azadeh. Thank you for joining us.
Thank you so much, Mary Meg, and thank you all for making time to join us today. Again, my name is Azadeh Irfani, Director of Policy with NIJC. I'm really honored to do our work alongside my colleagues Jesse Franzblau and Cecilia Mendoza. We lead both federal and state and local policy work within NIJC. I'm going to kick us off in terms of this, the updates that I have to share from 2025 and looking forward to 2026, which is the way in which there is a deepening gulf between Congress, the administration, and the rest of us. What we're seeing within Congress in 2025 is an unprecedented amount of money being sent to ICE and Customs and Border Protection, which I'll refer to as CBP, in terms of the types of crackdown, the types of abuses that Mary Meg mentioned that are unfolding in our streets and within our communities. So in 2025, 2 months into the Trump administration, we had already seen people sent to Guantanamo Bay, the use of military planes to conduct deportations, this very theatrical and cruel display of attacks on cities like Chicago and other parts of the country had already happened. And nevertheless, Trump administration was demanding more money, and Congress obliged by March of 2025. So 2 months in, they already gave them about half a billion dollars more money to continue their crackdown on our communities. Deeply, deeply out of sync from what we were seeing, what the public was seeing, and the enabling essentially the executive branch to continue forward. By July, that the amount of money that went in the direction of ICE and CBP ballooned to levels we had never seen before. So 170 billion is roughly what we have estimated from perusing the reconciliation budget bill, which was a bill that was passed in the summer, and that gave to various agencies, not just ICE and CBP, but also the Department of Defense and the Office of Refugee Resettlement, all for the purpose of essentially giving more ammunition to this administration to conduct its crackdown and constitutional violations on a scale never seen before. So at the same time, Congress also passed essentially permitted the use of fees or fines on immigration forms of relief like asylum and appeals and protection applications for children who have been abused, essentially charging them hundreds, if not thousands of dollars just to have access to those basic protections. All of this is a lot, and we break it down in a lot more detail in some explainers that we're posting in the chat for you all, and that will be in the follow-up materials that you receive as well. But again, this means this indicated the ways in which Congress was truly on a path that was largely binding to every demand of the administration, and not and sort of abdicating the duties that it had to act as a separate and apart branch of government that is holding the executive branch accountable where there are abuses. And already in 2026, we are seeing an alarming concern also in that same direction, because Congress is poised to pass another bill that could potentially give more money to ICE and CBP. That bill is within the yearly funding stream that is called the appropriations process. And it basically, they are poised to fund more beds in ICE detention and more funding for the types of abuses that, again, we've been witnessing within cities like Chicago and Los Angeles and Minneapolis. So you'll see in your materials an action alert, because it is truly unconscionable at this moment to give a single dollar more to ICE or CBP, given what we've seen their record to be. Certainly with the murder of Renee Nicole Good, it was abundantly clear to many of us that their actions should no longer be funded at the very least, and that there should be serious accountability measures imposed. This is not what this bill would do. It would simply continue the status quo and embolden them further. So we hope that you will join us in urging your member of Congress to stand up and oppose that additional funding. And more money means more violence. So on the next slide, we will talk about what we've been seeing so far. What we've been seeing so far is more deaths than ever before in the past 2 decades, at least. So, in the past 2 decades, we had never seen as many as 32 people die in ICE detention as we did in 2025. Already in 2026, there have been 4 deaths, and we're not even halfway through the month. This should alarm all of us because deaths in ICE detention, for the most part, are preventable, according to medical experts who conducted a study a few years ago reviewing many of the deaths that occurred in ICE custody. And they're also a product of the kind of overcrowding and neglect that is endemic to ICE detention. And with that in mind, it's alarming that we have about 68,000 people that were jailed in ICE custody for no reason other than civil immigration violations at the end of the year. And it's worth reminding here that, again, the US is at odds with the rest of the world. Nobody likes to jail immigrants as much as the United States. And unfortunately, this is a trend that is continuing onward instead of being restricted. And so we can expect that if the administration continues to jail people at this rate, we're also going to see more deaths in ICE custody. And as mentioned before, we're going to continue to see the kind of militarized assaults that we saw in Chicago, in Los Angeles and Minneapolis and many other parts of the country, where ICE, CBP, and other federal law enforcement agencies are essentially acting like a masked militia that is plucking people from the streets, entering homes without warrants, and picking up people in plain violation of the US Constitution, often picking up US citizens, often impacting children and separating families. So the kinds of harms that that we should all be condemning very clearly and yet have become common day occurrences and things that we witness on a weekly basis because of this administration. The other thing that we have seen is that where members of Congress have stood up and tried to enter ICE detention centers and conduct oversight, which is their right under the Constitution and also under a US statute, they have been blocked by this administration. So there was actually a lawsuit last year by members of Congress who were essentially complaining that the administration is trying to override their legislative duty. And a judge sided with them and issued a ruling that sought to restore their right to visit these facilities and conduct oversight, because this is a time like no other where we need eyes on the ground and accountability. So it's really important for our members of Congress to be involved. NIJC has been advocating for this on Capitol Hill and speaking with various members of Congress, lifting up a toolkit that we created related to the importance of conducting these oversight visits. Already in 2026, we have seen Secretary Noem issue a memo where she has sought to circumvent that judge's ruling and saying that, they should be emboldened to turn away members of Congress so long as they can claim that they're using funding that is from this $170 billion bucket that I mentioned earlier from last July, as opposed to the yearly funding that they receive. This is a truly untenable argument, but also makes clear the ways in which the administration has no limits in terms of trying to override other branches of government and impose what should alarm all of us in terms of the authoritarian trends that we're seeing. In terms of the direct impact on our communities, I do want to draw your attention to the map that you're seeing at the right of the screen, which is the number of people who, or the locations where people are sent across the country after the crackdown that happened in Chicago under Operation Midway Blitz. It is astounding how far people are sent. It is one of the daily indignities that families have to suffer in terms of locating their loved ones and actually showing up for them, finding counsel for them. It is designed to make it impossible for people to get the help that they need, and including in terms of representation. So that's another aspect of supercharging the system as we know it. It is emboldening them further to do to send people to these remote places so they are deported and disappeared permanently. On the next slide, I do want to talk about the next trends that we have spotted with the administration. So one of the other pieces of the Trump administration and its collaboration with Congress is that we have seen the House primarily, but in part also the Senate, advance a series of bills that were aimed to uphold the kind of criminalization narrative that we keep hearing from the administration. For the most part, the kinds of bills that are advanced follow a particular blueprint. They often are named after a victim of a tragic death or a horrific death in some cases, and exploiting the name and legacy of that victim in order to advance a bill that will criminalize immigrants, large groups of immigrants, and violate their due process rights. The second piece of that blueprint is that these bills are often very, very duplicative of the kinds of laws that are already on the books. Few people know this, but some of our pro bono partners on the call probably know this, which is that the immigration law that controls most cases, the Immigration and Nationality Act, is already quite punitive when it comes to people who have had any contact with the criminal legal system. But these proposed bills have tried to essentially punish them further and duplicate the punishment that already exists in the books and expand it. And that's the third part of this blueprint. They are trying to expand it to people who have alleged conduct or mere charges in order to make sure that they are also barred from any kind of immigration protection. That means excluding domestic violence survivors, people who are longtime neighbors, folks who have been racially profiled and falsely accused of certain crimes. All of those people could be subjected to essentially barred from immigration protection simply on the basis of these criminalizing bills if they become law. So we're very concerned about that trend that we've seen from Congress. And, one of the last bills that we saw last year has shown also that they're not sparing children. One of the bills at the end of last year was permitting body searches, invasive body searches of children at a very, very young age. And, again, under the premise that children are essentially, within the same criminalizing lens, are potential gang members and looking for tattoos and marks on their bodies and whatnot. This should alarm all of us, and it's part of the playbook of this administration that has made it into the legislative branch that we should all be concerned about. The last two things I want to mention is that there has been a lot of attacks on nonprofits. There has been a lot of attacks on lawyers and legal advocates. It's all part of a retaliatory campaign against anyone who is standing up to the cruelty of this administration. So it's going after the lawyers is one way to go after immigrants, because they know that People who have no attorneys, who don't have someone on their side, are more likely to face a deportation order. So that's another trend that we've seen, and that's been really alarming. And relatedly, we've also seen the administration cut off all sources of funding at the federal level for immigrants. That includes unrepresented people, detained people, individuals with mental health disabilities, families that were separated under Trump 1.0, and unaccompanied children, with one notable footnote, which is that unaccompanied children so far have been able to fight back and get the funding continued in court. But it is deeply, deeply concerning that these type of attacks on funding and legal representation are truly one other way in which the deportation pipeline moves forth. So the funding for legal services continues to be very much in jeopardy. On the next slide, I want to end with one note of hope, which is that even though it has been a very difficult time, and the last year was very challenging, this past week alone was deeply challenging, it takes a long time to build an anti-immigrant narrative, and the administration has capitalized on it, but it also will take time to dismantle it. And the first step is to have clarity on the situation that we are facing. So we know that our immigrant communities make us all stronger. We know that this narrative that immigrants are bringing crime or are criminals is false and frankly essentially advances a type of racializing narrative that we've seen in the past. We also know who is profiting, because this administration, including various cabinet members, has been closely entangled with private prisons and other ICE contractors. And it's very important for them for us to know who we are facing and the kinds of abuses that they are advancing in this climate, in order for us to turn the page and move towards a more hopeful day for immigrants. It's also very clear that legal representation is pivotal, and that in order for us to fight back, people need to have counsel by their side. So the attacks that we're seeing, in a way, are highlighting the power that we have as a community to fight back. And in particular, the value of having representation for people who are in detention is more important than ever, because it can mean the difference between a person being sent to a country around the world without any semblance of due process, and their right to pursue the protection and have the day in court that they deserve. That's a pretty pivotal difference to make. And last but not least, I think Chicago and Illinois have been at the forefront of fighting back, and that is a source of pride for many of us, because we are seeing that these retaliatory acts from the administration are also demonstrating that there's power in our state and local work. There's power in how our cities are fighting back, and we are in need more than ever to continue building on that and to advance it further. So with that, I'm going to pass it on to my colleague Jen. Thank you.
Thank you, Azadeh, and hi, everyone. Thanks again for being here. So my name is Jennifer Babai. I manage our adult detention project, which means our whole goal of my team is to provide legal representation to adults that are in ICE custody. That's the Immigration and Customs Enforcement, with an attempt to either get them released as soon as possible or to secure some sort of pathway to relief so that they can rejoin family and loved ones in the U.S. but as I begin and we go into the next slide, I really just want to mention that all of the information here is thanks to so much collaboration with incredible attorneys and legal assistants that I've been honored to work with for this last year. And so with thanks to them, here is a tiny sliver of what's going on with adult detention. And the goal is to help you understand why is due process at risk, how is it being attacked, and how are the agencies that manage detention being utilized to ensure that immigrants, as many as possible, are deported. So first, let's focus on detention conditions. Conditions were bad before the Trump administration came back into office in January of last year. That being said, there are certain factors that are definitely contributing to those conditions worsening, and they're being utilized on purpose to intimidate and abuse individuals that are in custody to ensure that they take deportation orders. So a tiny sliver of what that might look like. We're talking about lack of access to confidential legal calls, to meet with an attorney, to consult on your case, lack of private space to talk to your attorney, lack of food or appropriate food that is frozen, documented abuse and intimidation by guards. This is in multiple facilities across the US, and an increased use of solitary confinement as punishment for trying to ask for basic needs, such as acknowledging you are ill, you have a longstanding illness, you need access to medication, so on and so forth. In addition, as you read through these different conditions, something to keep an eye on is that last year, the administration immediately sought and successfully dissolved oversight offices that were once present within the agencies, both internal to the Department of Homeland Security and external. The goal of that, of course, being that there are less and less avenues for advocates and those confined to bring up issues that are happening when they're in custody. So let's go to the next slide. In addition to increasingly abhorrent conditions, we're also seeing a shrinking of pathways to release. There have been a multitude of legal battles taking place from last year to today. It's an ongoing issue as to who has access to bond to seek release from their immigration custody. Now, typically, your access depends on your manner of entry into the United States. Where did you enter? Was it at a port of entry? Was it in between a port of entry? Did you have lawful authorization to be here when you first entered? How soon were you arrested after you entered? How long have you been in the U.S.? All of these factors traditionally impact policy for who can apply for bond. From July of last year to today, what we've seen is the administration's willingness to use its access both to the Department of Homeland Security and to the immigration courts to change decades-long policy to make it so that nearly everyone in ICE custody is subject to mandatory detention. What that has resulted for on the individuals impacted is we're seeing increased family separation, and we're seeing more individuals give up their claims because of just how horrible it is to remain in detention. So a lot of the policy as to whether or not an individual has access to bond has been litigated in federal court. We now have a decision that you can read more about called Maldonado that was argued in the Ninth Circuit. Basically, where I would land now is to say there is legally access to bond. However, we are witnessing immigration judges that are taking individual stances, attempting to deny the fact that they have jurisdiction to decide whether or not someone should remain in custody. And so as an advocate, as an attorney, every single situation, every single case that you screen, you're finding that you are having to make complex legal analysis to try to decide whether or not you can convince a judge to even give your client a time in court to decide if they can be released. Let's go to the next slide. Okay, so I've talked about so far that conditions of detention and lack of access to bond are seriously impacting the due process rights of immigrants in this country, increasing arrests and leading to a majority of individuals being in custody and being stuck there. Another huge issue that is resulting in concerns over whether or not an individual can seek release and also actually get any sort of relief in immigration court is the use of third country removals. This is a 2-hour seminar in and of itself. So I think the most important thing to know is that the administration is purposefully utilizing their ability to deport someone to a country that is not their home without having a day in court as a means of threatening and spreading fear to ensure that individuals simply accept removal orders to their home country. A couple examples of how this has played out. We've seen the Alien Enemies Act, a wartime act, being utilized to send individuals to a prison in El Salvador. We've witnessed Guantanamo being used as a prison location for individuals with removal orders and for some individuals with active immigration court cases. We are also seeing people who have won protection from their home countries, meaning they have proven to an immigration judge that they would be tortured and or persecuted in their home country, who are still being deported to that country, which is in violation of their basic rights. In border areas, we're also seeing individuals literally driven to ports of entries and being told they have no choice but to walk across the border to quote unquote self-deport to Mexico. Again, these are all means of threats and of encouraging individuals to simply leave the US without actually accessing the relief they are eligible for. You can go to the next slide. And you'll get these slides later, but what I really was aiming to do here is to try to pull together with all these different means that the administration has been using over the last 12 months, what is the impact? One, as I've been repeating over and over again, individuals who otherwise would be able to win protection, have long-term status in the US or have a pathway to that status, are instead accepting removal orders. We are seeing openly racist and politically motivated arrest tactics, and these are harming communities. Chicago is a good example with the Midway Blitz, but it's not the only location where this has happened. Another big impact of this is more open collusion with local and state law enforcement together with immigration law enforcement. Something that happened between the states of Illinois and Indiana, and something that I witnessed myself on a road trip in Ohio, is the use of truck rest stops as an easy location for local law enforcement and immigration officials to target truck drivers and use that as a means of arresting individuals without having arrest warrants. Finally, an impact on NGOs. We are seeing an even bigger demand for legal services at a time where every single case is more and more complex. And so if you are an advocate or someone who is looking to take these kinds of cases, something that NIJC does and many of our partners is try to consult on these cases because they are so complex. And it has just been, I would say, to reflect on the last year, it's been in partnership with advocates and partnership with organizers who are doing a good job documenting what's going on and what tactics are being used, that we then pull that evidence to try to give each client that we have a day in court. So I'll pause there and turn it over to Lisa Coop, who will talk more about what is going on in immigration court and with access to asylum. Thank you.
Thanks, Jen. Hi, everyone. My name is Lisa Coop. I'm NIJC's Director of Legal Services. Just to echo the point that Jen made right there at the end, like this community of advocates, legal advocates, community leaders, organizers, people who are in the work, faith-based leaders, if we're looking for glimmers of hope and how we figure out a way forward together, that to me is one of our greatest strengths as communities, people trying to push back against these really horrific policies and practices. I'm running out of vocabulary to describe this system or this moment in time. It's bewildering, it's inscrutable, it's not a system that resembles one of justice in this moment. And that's really hard to figure a way through and to walk with our clients and to advocate for them. And so if we move to the next slide, we talk about due process as sometimes feeling like this maybe academic or nebulous thing, but in really concrete ways, people aren't being given a day in court. And so in any functioning system of justice, people should have an opportunity to put forth their evidence, have a fair adjudicator hear their case and weigh what they put forth their evidence and determine whether or not they should be granted relief and protection under our laws. This is our history. This is our system. This is who we are. But that's not what's happening right now. So, at the beginning of this administration, we understood that now there was no prosecutorial discretion. There were no people who were priorities for removal or not. And we're seeing that play out. In the Q&A, I saw a question about, how does this change something like naturalization? Well, the risk assessment that we make with everybody we represent is very, very different, because now when people expose themselves, even by filing an application for something for which they qualify, they're giving their address, they're giving their familial information to the government. It's being used against them. People are being arrested in their homes. People are being arrested while they're leaving Walmart. People are being arrested on their way to church or daycare and so forth. And so this really ambient fear of immigration prosecution and enforcement is really, really present, whether you live in a state like Illinois, where there's a midway blitz and there's constant, enforcement happening in the streets, or in a place like Indiana, where I live, where we have our state and local governments cooperating with ICE and turning people over after traffic stops into ICE custody and them landing in immigration jails from there. So we're seeing suspensions of adjudication. So again, Azadeh talked about these fees, fines, delays that are happening within the system. That's just escalating, and people who are eligible for benefits now maybe can't afford them, or things are just stagnating. For example, we saw the suspension of applications relating to Afghans. We're seeing our Afghan clients be taken back into ICE custody, sitting in our jails when they have asylum applications pending, because our government is practicing this collective punishment against groups of people that they deem, that they're trying to cast as threats, when in fact these are, people that we should be welcoming into our communities, and indeed have welcomed into our communities and are now casting out. So the courthouse arrest last summer in Chicago and in many places around the country, we saw a really strong ICE presence in court, even though that's largely stopped in part by litigation filed by our colleagues at NIJC and other organizations around the country. There's still a really strong chilling effect, and people are scared to go to immigration court, which means people are being ordered deported without ever having a chance to talk to a judge and explain their case. Pretermission, Jen mentioned in passing, this is this practice that became very in vogue at DHS a number of months ago, where the government is trying to cancel asylum applications before they even begin. So they're filing motions to tell the judge, hey, judge, you don't even need to hear this asylum case because this person should be removed to a third country, or this person has failed to state a claim. So this asylum claim, based on what we can see in this asylum application, there's not a legal basis for the claim. So even though we believe that there are lots of ways to establish one's eligibility as a refugee, they're saying, no, there's no legal path forward. And so, judge, you should just cancel that application. Or we're seeing asylum applications canceled because there's maybe a mistake on the application, or some very technical, nuanced, and oftentimes not even a real problem with the application that's being used to cancel that application. So we can go to the next slide, and I'll talk a little bit more about some of the ways asylum is being narrowed. And I really want to maybe talk most about these Board of Immigration Appeals decisions. So the Board of Immigration Appeals is the court above the immigration court that sets precedent decisions for all of the country to follow in the immigration context. And in 2025, they published 71 decisions. And I didn't go back terribly far to see if that's an all-time record. That's an awful lot of published decisions to come out of the Board of Immigration Appeals. Every single one of those 71 published decisions went against the immigrant. So in a system where the immigrant never, ever wins, we cannot understand that to be a system of justice. We don't have impartial adjudicators right now. Of the 71 cases, 27 were protection-based relief. So those were asylum-based cases. In every single one of those 27 cases, the government was narrowing the path to refugee recognition. That's really problematic. And really sets a tone of, that again makes this path forward, this path to protection, really, really narrow and legally erroneous. So we can go to the next slide, and I'll talk briefly about what's happening to children, because just when we think our conscience can't be shocked anymore, the government seems to be coming up with some new awful and inhumane thing to do as to children. So we're seeing a real resurgence in family separation. Family separation under the first Trump administration was sort of one of these spaces where where it felt like there was finally an awakening to the injustices and a bit of a backlash against the Trump administration. We're seeing different iterations of family separation now, not so much at the border because the borders are very much sealed, but sort of as we're seeing internal family apprehensions, we're seeing children taken from their parents, parents taken into ICE custody. Children may or may not be going into Office of Refugee Resettlement custody or shelters. It's oftentimes very unclear and ambiguous what is happening to various family members when ICE apprehensions are happening. Children who are in custody are being coerced into taking voluntary departure or taking removal. They're being told that they're not eligible for relief when they are. They're being told that if they pursue their cases, their parents might be detained. And indeed, we are seeing some parents who try to claim their children as sponsors and reunify with their children who are in immigration custody be taken into ICE custody themselves. And so that's another iteration of family separation that we're seeing. And so this confluence of attacks on due process, attacks on asylum, attacks on the rights of children and children and families makes this a very alarming moment in the practice of immigration law. And I'm going to turn things over to my colleague Karen Zwick, who's going to talk to us about some of our litigation, because to me, that's another space of hope. You know, part of what we're doing as direct services attorneys right now is accompaniment. We're sitting in jail cells with our clients. We're sitting next to them in immigration court. We're going with them to ICE check-in appointments to try and protect against detention, or at least bear witness to it and document it. And so many of you are doing these things in different ways that are protective and that are laying the foundations for future accountability and hopefully future victories in the litigation space where we can start to claw back recognition of some of the rights of immigrants. So with that, I'll hand it over to Karen.
Thanks, Lisa. Hi, everybody. I'm Karen Zwick. I'm the Director of Litigation here at NIJC. As you've heard from Lisa and Jen and Azadeh, we've heard dozens of things that we could be litigating. And I think this slide, I chose this title for this section, Everything Everywhere All at Once, because the truth of the matter is we could be filing federal court lawsuits about every single one of those things. And we are doing as much of that as we can, though we can't obviously cover all of the things. So I'm going to try to focus my remarks on three areas where we are litigating. They're not exclusively the areas where we're litigating, but they're, I think, big ones, and they're consistent with what NIJC's overall consistent pattern of trying to use the stories of our clients and the experiences of our clients to inform how we fight back and how we invest in like protecting immigrant communities. So the first section of this is on interior enforcement. Interior enforcement, frankly, is a little bit of a bland way to phrase what is happening right now when we're talking about the use of military helicopters, masked officers, flash grenades, armed weapons, basically outright kidnapping of people on the streets. All of this is illegal and warrantless arrests, involves illegal and warrantless arrests. NIJC has a case that we've filed during the first Trump administration called Castañón Nava, which we have revived. That addresses the use of warrantless arrests and tries to challenge both these tactics and also the practice of using warrantless arrests. That case, next slide, please. That case has gone through like a long storied history, I guess, if you will. But the bottom line is that during the first Trump administration, when there were arrests of about 200 or 300 people in Chicago, we thought that was outrageous, and we filed this lawsuit. Little did we know that this time around the numbers would be closer to 4,000. So our argument was basically that ICE cannot make an arrest without having a warrant, without probable cause, both as to whether or not someone is present in the United States unlawfully and whether or not they are likely to become a flight risk. And the government has consistently failed to do that flight risk analysis. We won a consent decree about that in 2022, but of course, since January of last year, that consent decree has been violated right and left, and so we filed a motion to extend and enforce the consent decree back in March, and we have been in persistent litigation throughout the whole year on this topic. And you know, I don't really know what to say in terms of like how litigation actually will make a long-term difference, because we thought at one moment in this litigation, for example, that we were going to win the release of hundreds of people. The government appealed that decision and got a stay of that decision. But I do remain hopeful in two substantial respects with respect to how this kind of litigation can make a difference going forward. One is that this case and the issues that we argued in NAVA back in 2022 and that we continue to argue have been taken up all over the country. So you'll see at the bottom of this slide references to a case in Colorado and another one in DC. There's a case that's been recently filed that's being filed in Minnesota. Just if it wasn't filed today, yesterday, it's going to be filed today, making these same arguments. So I do think that there is a lot of hope to say, we're not asking for anything crazy. We're just asking for the Department of Homeland Security to follow what the statute Congress wrote says about when people can be arrested without a warrant. So I do think that there is some hope and that this issue is being won around the country in many jurisdictions. And then while I don't necessarily feel a lot of hope that it will ultimately result in release of people in mass, like we had previously hoped back in November that it would, I do think it will hopefully help us to prevent another like iteration of Operation Midway Blitz going forward in the Chicagoland area. Next slide, please. So that was a very quick discussion of interior enforcement. Another area that NIJC obviously cares a great deal about is access to asylum. Lisa talked about how asylum is being impacted by decisions from the Board of Immigration Appeals and how activities at the immigration courts are impairing people's ability to seek asylum in the interior. Our litigation on asylum access involves some of that stuff, and it also includes access to asylum for people who are coming to the country. So, for example, we filed a case at the beginning of 2025 with a number of partners challenging the president's proclamation that there was a quote unquote invasion at the southern border that basically completely ended access to asylum and related protections like something called withholding of removal. We won that case at the district court. The government has, of course, appealed, and we're pending at the DC Circuit right now. We've also challenged this issue that Lisa mentioned regarding these preterm missions of like shutting off access to asylum to send people to another country before they can seek protection to their home country. I want to note like a very pernicious element of this. Lisa framed it rightly as shutting off access to asylum before a case can begin, but the government is filing these motions also at the 11th hour. So they'll file them like it's not really before the case has begun. It's like the day before someone's merits hearing. So for those of you who are pro bono attorneys working on cases, I want to express my sympathy and thanks to you because this is coming up at like very late in people's asylum cases, and it's really hard to be able to defend against it on an individualized basis, which is of course why we're trying to litigate to deal with it on a more systemic basis. I'm going to skip the next one just in the interest of time. So next slide, please. And then on this asylum thing, I want to also just reference one really big thing that I think we're looking toward in the future. Many of you will recall from the first Trump administration a rule from December of 2020. We called it the death to asylum rule at NIJC. Some people called it the mega rule. It had about 60,000 comments, and basically every single element of the asylum and the refugee definition was impacted in some negative way, including, for example, whether or not certain people can be members of a particular social group, how the 1-year filing deadline applies. It touched basically every single aspect of asylum. Happily, that rule never took effect because the person who signed it, Chad Wolf, was not properly serving as a Secretary of Homeland Security at the time. So we beat that rule at that time on a technicality. But unfortunately, Secretary Noem has since ratified that rule, and it is now poised to take effect again. So we are getting ready to file new litigation about an old rule that is coming back to bite us, I guess, in the asylum space, in the hopes that we can keep that rule from taking effect yet again. Next slide, please. And finally, I just want to end on this like topic of due process and fair proceedings because back in the day when I first started at NIJC, we would talk about due process, and I wasn't and like fighting to protect due process. And I thought that it was just a little bit too generic to understand what we really were talking about. But now it's so fundamental that it's like really in our face. We're talking about people showing up at their immigration court hearings to get arrested and have their cases terminated or dismissed so that they can be placed in different proceedings, like expedited removal proceedings. So we're challenging those sorts of things. We're challenging the things that Azadeh mentioned about like access to funding and access to counsel, including there's one limited program for people who can get appointed counsel. Normally, you don't get counsel if you are in immigration proceedings. There's no like appointed counsel like in the criminal justice system. There is one pretty narrow exception for that for people who have been adjudicated to be incompetent based on mental health concerns. The government, of course, tried to terminate that funding and say that those people just need to go forward without lawyers, and that people who or had already been appointed to represent those folks who in their existing proceedings just needed to either do it for free or stop doing it altogether. We challenged that, and that is one bright spot. We won that litigation, and so that program does continue to exist. There are other funding challenges with respect to more limited elements of aspects of federal funding for things like Know Your Rights presentations that we're also involved in. But really, I will say that from a fairness perspective, from my perspective as a litigator, cruelty seems to be the point. The whole entire reason, everything they're doing is make it hard, put people in jail, separate people from their families, separate people from their lawyers, limit their ability to communicate with the outside world, make it such that they feel that they have no option but to give up. And so that's what these cases are designed to fight against. Next slide, please. And along the same theme of cruelty as the point, I want to just flag one new thing that we're looking at and one revival of an old thing that another old thing that we're going to be revisiting in the next year. Starting with the old thing, again, back in 2020, we challenged a rule that limited the process of seeking an appeal to the Board of Immigration Appeals. That rule basically did things like say that you couldn't get an extension, you couldn't file a motion to reopen. It had limits on how many cases a judge could hear. It gave the immigration judges the ability to weigh in on whether or not they thought that the appeal was proper. In other words, the judge could write something to the board to say whether or not they think that the appeal should be dismissed, and the government was supposed to listen to what the judge said. We won a case against that rule, and then in 2024, the Biden administration issued a new rule replacing that rule. But we are now learning that we're expecting that rule to be the old one to be revived and much worse. We are expecting things like shorter access to appeals, meaning like a 10 or maybe 15-day time limit from when someone's case is decided at the immigration court level to file an appeal, and also a streamlined, like every case that is appealed is denied unless some larger element of the board signs on and wants to challenge it, meaning like you need, for those of you who are lawyers in the room, you need en banc effectively of the board, or like more than 3 board members to agree to hear a case before the case would be considered. So we're trying to get ready to challenge that. And also another one in the cruelty is the point category is the government, in addition to taking people into custody, detaining them illegally by arresting them without a warrant, holding them in custody under supposed mandatory detention provisions that are not mandatory detention, in other words, denying them bond, like Jen mentioned. There's now another new policy for people who, once they're in detention, if they have a case pending before United States Citizenship and Immigration Services and not in the immigration courts, they're no longer going to do their fingerprints, which of course means that they can't adjudicate those claims. The agency can't consider those applications for relief because the fingerprints and the biometrics are a necessary element, but yet the government is taking a person into custody and will not give them the thing that is necessary for completion of their applications. So these are the kind of things that we're facing and that we're trying to be ready to deal with in the coming year. So it's going to be busy. It's going to be a lot to take on. And we're just really thankful for all of you for being here and your ongoing support. And with that, I will pass it to Charlotte.
Thanks, Karen, and thank you all so much for the thoughtful questions. I'm going to spend just a moment talking about ways for you all to get involved and really appreciate all of you who are saying, like, how can we help? We know that there aren't the most satisfying answers to that question, but we're going to keep trying to share some ways that you can consider getting involved. So first, to advocate. So speak up on behalf of politicians who are taking what are now controversial pro-immigrant positions. Also, hold your elected officials accountable to keep our communities safe. And some ways to do that are through NIJC's action alerts. So we're going to drop a link in the chat to an upcoming action alert that was just started yesterday. This is to urge Congress to reject additional funding for ICE in the fiscal year 2026 budget bill that Azadeh was mentioning earlier. Use that link in the chat to send a message to your representatives. We know and hear you that it can feel like those messages sometimes go into the void, but they do matter, and they are one of the ways that you can continue to use your voice, regardless of if your elected officials, where they fall on these issues. That sort of pressure and encouragement is meaningful and makes an impact. The second is to invest. NIJC relies entirely on your support, philanthropic support, to sustain and expand our work, which, as you can see from what my colleagues just shared, is getting harder in these circumstances. So any sort of unrestricted gift is particularly powerful for our ability to be flexible in the ways that we respond to what we're seeing in our communities. The third is to stay informed, which you all are already doing by being here. You can register for NIJC's newsletters and keep attending webinars like this one and those that are put on by many of our partner organizations as well. But you should also try to engage with what pro-immigrant organizations are doing locally in your community. That's often one of the best ways to tap in and where there's the most kind of like in-kind, tangible sort of support that you all are looking to get involved with. And that leads me to the fourth bucket, which is to volunteer, whether that's with us or in other ways. We mostly, or I would say exclusively, work with legal volunteers or interpreters. And we've been overwhelmed by increased interest in pro bono support for our work. So first, want to say thank you to all of you who have reached out. Our greatest need right now continues to be full scope representation, particularly for asylum seekers. We do only place asylum cases with attorneys who are at law firms or corporations. But if you are a solo practitioner hoping to get involved, we sometimes have other case types that are available, and you can find out more on our website. We do happen to have our annual asylum training tomorrow remotely via Zoom from 9 a.m. to 11:30 a.m. Central Time. So if you're eager to learn more, or if you want the recording, you're going to see in the chat again a link to register for that training. And then finally, if you are a fluent language speaker, please consider adding yourself to our volunteer interpreter list. And if none of these opportunities apply to you, I just strongly recommend tapping again into your local neighborhood rapid response efforts, because there certainly is a role for each of us to play. It may feel overwhelming hearing all of this, but you should figure out what your avenue is to tap in and then do so. And I know we covered a lot of information in a short time and now have just a few minutes left. The panelists have agreed to stay on until 5 minutes after the hour to answer a few questions. So right now we are going to stop screen sharing. I have a couple questions queued up that some of you have asked to get us started, but if you have any last ones, you can submit them via the Q&A feature, recognizing we might not be able to get to them all. So I'm going to go ahead and head into our first question just in the interest of time, and please feel free to stop screen sharing so that we can see all of the panelists. So this one is for you, Lisa. Can you tell us how have NIJC's services been impacted by ICE and what we've been seeing?
Yeah, I mean, I think most directly, like, we have all become detention attorneys. You know, this used to be sort of Jen's corner of NIJC's work, and all of us have clients who have been apprehended on their way to work or picked up, you know, at their home or at, you know, their place of worship or whatever. And so we've really quickly had to build a lot of expertise and do detention work. A lot of us have learned how to do habeas work, you know, to try and file lawsuits to get our clients out of detention. But I think there is also just this different risk assessment. Like, we don't know now if we go to a United States Citizenship and Immigration Services interview with our client for citizenship, for their green card, for some other benefit, there's a chance that ICE will be there. And that's really new and different, you know, this merger of the benefit side and the enforcement side. And so things, you know, just following along on the theme of what can people do. The accompaniment work that we've seen some community groups do has been incredible. If you have someone in your community that's organizing accompaniment to ICE check-in appointments, that can be really significant and critical. Court observation has been huge. We're learning some of the things that we know about what's happening in the Chicago courts. We know because there are incredible volunteers who are very organized and coordinated who go in and observe courts. And I know that's happening in Indiana as well. And that's something that's been really significant and made a difference in the way we're able to do our work. So I think, yeah, it is a very different world now than it was a year ago when we were entering into this administration. And I think a lot of our worst fears are coming true, and they're going to think of new and different ways to be cruel to immigrants. And so our work will continue to change. And I guess just, to the point of this is a lot of really complicated intersecting information that we're wading into today. In immigration law, there's no appointed counsel. And so if you're bewildered and somewhat baffled by what we're saying, imagine a non-citizen trying to navigate all of these issues without the assistance of counsel, because that's what happens when you don't have a pro bono attorney or a nonprofit or the ability to pay a lawyer. And so that's our ongoing mission, is to figure out what are these interventions and things that we can do to protect immigrant communities.
Thanks, Lisa. I'm going to go to Karen now. Karen, this is a two-parter from two different people. So in the past year, we've seen the Trump administration defy court orders. How is this impacting your work? And then relatedly, we're hearing organizers and community members start to question why we should continue to document when the courts are not siding with us. What can we tell community members about what's possible?
So in terms of the courts not following orders, I think that that's a tough one, right? Because how does it impact us? It impacts what we ask for. So in cases in the past where we might have thought that declaratory relief or vacatur was sufficient, we might sometimes now ask for injunctive relief, though of course the courts have also placed like pretty stern limits on how and when injunctive relief can be available. Injunctions are more significant than declaratory relief because they allow us to go back and say, well, they're not doing what they're supposed to do. It's sort of a prohibition, and it creates an enforcement mechanism. And of course, our whole entire NAVA litigation is about us trying to enforce a consent decree that we won, and so trying to get the agencies to follow what they've already previously agreed to. So that's a big part of what we're doing. And then in terms of like why should we continue to go forward, and how, like, I just want to acknowledge and name that the despair is very real, and people are feeling, I think, a lot of hopelessness right now about a lot of elements of immigration law and practice. What I can say is, continuing to document this stuff, there's going to be a time where this administration and this policy, this is not the audience that we're talking to, and continuing to document this stuff for the future is going to give us tools that we will need in the future to advocate for bigger, broader systemic change, whether it's via Congress when we finally get it, whether it's via the courts, whether it's via just like changes in public opinion. I think all of those things really matter. And so even though all of this can feel a little bit like banging your head against a brick wall, I think it's really important for thinking, if you care about immigrants in this country, and if you're in this Zoom, I think it's safe to assume that you do. If you care about immigrants, I think that continuing to beat the drum is really important for the future.
I know we are a few minutes over, and I think that is a good note to end on. There are a handful of questions we weren't able to answer, but really appreciate everyone for submitting your questions. We will be sending a follow-up email by the end of the week that has the recording. It'll have a PDF of these slides that includes the links to everything that was shared via the chat. It will have our Know Your Rights materials. So I just want to say thank you to everyone who joined and to our panelists for being here today. NIJC will not give up, and we are grateful to have all of you as partners in this fight with us, and we look forward to staying in contact moving forward. So thank you for your time, and have a good rest of your day.